webcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Don Rowe from Smith Brothers. I'm the Employee Benefits Service and Compliance Leader, and you're joining our webinar today on the Massachusetts Family and Medical Leave Act. We'll be working with Rick Zebak today as our attorney to help guide us through the conversation. I'd like to thank everybody for taking their time to attend this. I think it's going to be very much worth your time. You know, as frequently happens, Massachusetts employer compliance items tend to dominate the landscape, and this is another issue of that. So we're going to discuss the latest proposed guidance. The latest was issued on March 29th from the newly created Department of Family and Medical Leave concerning the Massachusetts Paid Family and Medical Leave Law. This affects all employers with Massachusetts employees, and we'll be getting into some of that during the presentation. It is, and really it is a compliance item related to employers because contributions begin July 1st, just 3 months away, and we'll be talking more about that this morning. Final guidance will be issued before July 1st, and we have no doubt there are going to be changes to the administrative rules, but we'll continue to keep everybody updated throughout the process. So again, we're reviewing today the latest guidance to help bring you all up to speed. I talked earlier, today's speaker is going to be Rick Zebak. He is an ERISA attorney and a valuable strategic legal partner of ours here at Smith Brothers. Rick is the founder and owner of a boutique law firm that specializes in ERISA and employee benefit matters, RAS Law. He has been providing legal counsel on health and welfare benefit issues for over 30 years. So just a couple of housekeeping details before we really get underway. All phone lines are and will remain muted during the presentation to avoid background noise, so you're all on mute. A PDF copy of today's PowerPoint presentation can be found in the handout section of your dashboard, which is hopefully on the right-hand side of your screen. There is going to be time to address questions at the end of the program. Now, we're not going to open up the phone line, but you will also see on the right-hand side of your screen a questions section. So if you have questions along the way, please type them in there, and they will be answered before the program concludes. We're going to try to do our best to get as many of those as possible. So again, thanking you for your participation and confidence in Smith Brothers. And without further ado, I'd like to turn this over to Rick Zebak. Good morning, Rick.
Hey, good morning, good afternoon, good night, good evening, whatever it is. Hi to you all. And again, I want to thank Smith Brothers Insurance and Smith Brothers Employee Benefits Consulting Group for sponsoring this. On behalf of myself and them, I want to thank you for taking the time out of your schedule to do this. I couldn't have done today without Don Rowe, who you just heard from, keeping after me, making sure I was on task and getting my slides together and what have you, and also Don Poulin, the two Dons, Don Squared, who I deal with most often at Smith Brothers. So today, yes, we're dealing with really, I guess we call it the latest of guidance with the Mass Family and Medical Leave Law. It was enacted July 12th last year, 2018, and we're fast approaching July 1, which is really the first major benchmark for employers. And so this is a great time. I know that Don mentioned that we, and I will as well, that we do have final regs that will come out by July 1. And there are always tweaks, but after seeing the draft regs that came out in January, and the listening sessions that were held across Massachusetts, There ended up being about 10, I think, 10 or 12. So the Department of Family and Medical Leave really did, a yeoman's work in trying to get everyone's enough hearing time. There were a lot of written commentary that was sent in. So the March 29th regs, which is what we're talking about now, which are proposed regs, really do take into account, I think, most of the commentary to the extent that they can be taken into account. And I know that the Department of Family and Medical Leave feel constrained, as they should, by the statutory provisions. So even though you might have suggested something that you really thought was a great idea or something that should be clarified or what have you, and you sent in your comments, it's possible that you didn't see them in the March 29th version. And the reason being is that the Department of Family and Medical Leave will again feel the restraints of the actual statutory language. They can't change anything in the regs that already appears in the statute. Having said that, very quickly, the paid family and medical leave, you'll see that as PFML as the acronym throughout, is administered by the state, Massachusetts. There's two new entities that have been created. One is the Department of Family and Medical Leave. That's the administrative agency that is operating this program. They did not exist prior to the statute being enacted. The other one is the Family and Employment Security Trust Fund. That trust fund, again, did not exist prior to enactment of this law in July of 2018. Just a note that the trust fund is will be used solely for the purpose of paid family and medical leave. It will not, and administrative costs of the department, but it will not be used for other things. And even if this family and medical leave program were to cease in the future, those funds are never, ever, ever transferred into the general fund. They will be used for run-out claims, etc. Although this is a private program or a state program, it's an employment-based wage replacement. If you're not employed or within a few months of being employed, you as a covered individual will not have any eligibility to participate in the program. All right. It's based on average weekly wages, and any claims for benefits are going to be submitted to, they're going to be adjudicated by and paid by the Department of Family and Medical Leave. And my caution to all of you, and you've probably figured this out already, is that although this is a state program, right, the money is coming from the state to pay these benefits. Okay, claims are being adjudicated by the state. There still is a significant burden on employers. Okay, basically, it's not your program, but you get to share in the pain. All right, because the paid family and medical leave law creates notice requirements, funding requirements, quarterly reporting requirements. You got to collect payroll taxes, and when claims are submitted, they won't be submitted to you. They'll be submitted to the state, to the department, but the department will be back in touch with you for certain information. So you can see that although it's a state program, there's a lot of places where this program touches you as an employer. There are also going to be some costs associated, and not just, it'll be administrative costs, as you can see, because of the increased administrative burdens. You will also, as an employer, unless you have an average aggregate workforce that's less than 25, you as an employer will have your own contributions to make towards this program. But the largest cost, significant cost to employers, is going to be the fact that when leave is provided, you as employers, to the extent you have an employee who's enrolled in the medical plan, you need to continue to provide the medical benefits under the same terms and conditions, which means you as an employer, if you're paying, making up a number, 75% of the cost of coverage, and that person goes out on leave, you're going to continue to pay 75% of the cost of coverage. And the tough thing here is that the state is really spending out of your checkbook. because what happens is you have no control over whether or not the state is going to grant leave or not as applied for. All right. But when they do, you automatically are now plugged in on the cost of medical coverage. All right. So your cost essentially for continued medical coverage is really being determined by the state in whether or not they approve a claim or not. And I might suggest to you that claims will be liberally adjudicated. All right. Benefits are basically four. We have wage replacement. And I'm sure you're aware of the cap of $850 a week. That is adjusted annually. Job protection benefits are now included in here. We just talked about the health plan protection, where you as the employer must continue to contribute and provide the coverage that was provided before they went out on leave as if they had never left. Okay. And then there is a prohibition against you as employers retaliating against individuals who have taken this or seek to take these benefits. Now, the wage replacement formula is basically a combination of the state average weekly wage and the employee's average weekly wage. Here's the good news. You as an employer don't have to calculate either one. Okay? It'll be done by the state. Okay? And the way this works is you look at the employee's average weekly wage, and then if it's that portion of the average weekly wage that's less than or equal to 50% of the state average weekly wage is replaced at 80%. And the amount of the employee's average weekly wage that's greater than half of the state's average weekly wage is replaced at 50%. Again, it's capped. The weekly wage replacement currently is capped at $850. Now, that will be adjusted each October 1, and it generally is the maximum benefit is essentially will be set at 64% of the state average weekly wage. So, as the state's average weekly wage is reset every October 1, essentially the $850 will be adjusted upwards as well to be effective on the following January 1. So, looking at the average weekly wage that was set in October of 2018, if we were paying benefits today out of this program, the cap on weekly benefits would be $880, not $850. And I'm sure that'll be adjusted again as part of the average weekly wage being increased in 2019 and 2020. All right. Now, what is the employee's average weekly wage? It's the same amount that the State Unemployment Insurance, the DUA, Division of Unemployment Insurance, determines for unemployment insurance purposes. Okay. If you are a self-employed individual and you buy into this program, your average weekly wage is 1/26th of your earnings from the two highest quarters. As of January, there's really been a lot of movement in the last few months. If you look at the key dates, and this is as of January, so this is obviously not the current chart, but you can see that it's fairly simple, and there's not a lot that's here. We know that there were regs coming out in March, which they did. We know July 1 is a big date, and then we know that benefits begin to be paid in January and July of 2021. But today, you can see that a lot more of this timeline has been filled in, and a lot of that timeline will relate to considerations and activities of you folks as employers in the next few months. Okay? So right now, we're sitting right about there where the yellow arrow is, having just survived the March 29th regs. You'll see that for those of you who want to exempt yourself from collecting contributions because you feel that your private plan will be as good as the state plan, you're going to be able to apply begin April 2019. July 1, final regulations are promulgated and payroll deductions begin. And so that's where we start making those collections as we pre-fund the trust all the way through January 1 of 2021. And I might say, obviously, that we don't stop at January 1, 2021. It's just that the 18 months between July 1, 19 and January 1, 21 is the 18-month pre-funding period, and then obviously employers will and employees will continue to contribute on an ongoing basis. Also, we've now learned that all benefits will be available on January 1, 2021, except for family leave taken for a family member that has a serious health condition. And those benefits don't become available until July 1. Other family leave for other reasons, such as for bonding with the child after birth, adoption, etc., and things related to exigencies related to military issues and whatnot, all of that will kick in on January 1, as most folks had anticipated. So July 1's the date. It's, as Don indicated, it's 3 months away. So on July 1, we have to have a new model workplace poster in place. All right. And that means that it has to be posted noticeably at your location. If you have multiple locations, it's going to have to be posted in multiple places. It is also going to be available in other languages. So if you have 5 or more employees whose primary language is something other than English, you're going to have to provide the poster or post the poster in that language as well. Now, you don't have to worry about translating. The state has already done that. There is a state website, and if you go on the website, they already have posters in English and 12 other languages. Okay. In addition, on beginning July 1, there's a new hire notice that must be given to all employees hired on or after July 1, 2019. Interestingly, it does not require that you give the notice to current employees. And they've had an opportunity to fix that or to clarify that, and this is the way the language remains. So you must provide the written notice, and again, we're told that there will be a model notice, and it will be provided in several languages. Again, because if you have employees, 5 or more, where their primary language is something other than English, they're going to need the notice in that language. So they will be available in multiple languages. You will provide it to your all newly hired employees. And if you have 1099 contractors, okay, you have to provide the notice to the 1099 contractors as well. The key here is that these notices must be delivered within 30 days of the date of hire. And you might think that's pretty easy to do, to get the notice out within 30 days. However, there's a hitch, and the hitch is the notice is not considered delivered until you as the employer have received back from the employee a signed acknowledgement that they've received the written notice. And if you can't get a signed statement or signed acknowledgement back from them, you need to get a signed statement from them that they refuse to sign the acknowledgement, which is crazy because if they're not signing the acknowledgement, how are they going to sign the statement? Okay, so you do have 30 days to deliver, air quotes around deliver, this notice, but the delivery includes not only providing the notice to employees, but also getting an acknowledgement back, all within 30 days. Also on July 1, we start pre-funding the trust. This is when payroll deductions commence. And obviously July 1 is also the due date for the final regulations. So this is what the new model workplace poster looks like. This one's in English. It's just one page, and it will be posted along with all your other workplace notices that you post from time to time. Now, on the new hire notices, they have to contain certain things. And because they're model notices, chances are they're going to contain a lot of this right out of the gate. But what you want to look at is the second and third sub-bullet. Basically, although this is going to be a model notice, you as an employer are going to have to insert what the employee's contribution amount and obligations are going to be towards the coverage, as well as your own as an employer contribution amounts. And also, if you're hiring 1099 contractors, you're going to provide them with a notice with similar information. Now, that information is unique to you as an employer. And as you probably know, we'll see in some subsequent slides, that you have a choice as to how much or how little you contribute as an employer towards the cost of this program. And because you have a choice, whatever you choose needs to be put in the new hire notice. All right. Now, just very briefly, the paid family and medical leave, as you know, benefits begin January 1, 2011, or 2021, excuse me, except for if you need family leave to care for a family member with a serious health condition, those benefits roll out and are available on July 1, 2021. Medical leave, you can get up to 20 weeks per benefit year for a serious health condition of your employee. All right. Family leave, just like federal FMLA, is up to 12 weeks per benefit year, except it can be extended in certain cases for the care of a covered service member, military service member. These are per benefit year. What is a benefit year? A benefit year is a rolling 52 weeks that starts on the Sunday before the first day of the job protected leave starts. All right. Which means that depending on what your employees do or when they apply for benefits, the benefit year for each employee could be different, at least those that are taking or have been approved for paid family and medical leave under the Massachusetts program. Intermittent leave is provided. These regs that just came out made it clear that intermittent leave could be as short as an hour or more, up to several weeks. Okay. But the intermittent leave is not approved across the board. So, for instance, if your employee wants to take intermittent leave, family leave to bond with a child, it can only be taken if you and the employee can agree to it. Okay. Also, if it's the employee's serious health condition, it can be taken if it's medically necessary, and the employee's physician would make that call. Family leave due to qualifying exigencies out of having a family member in active duty or in pending active duty is automatic and can be taken, as is leave. If you're a self-employed individual, you can permit yourself to take intermittent leave. Okay. And the regulations make clear that even when you're taking intermittent leave, the job and benefit protections apply to that intermittent leave. Now, I want to hit this first after that summary, is there are a lot of folks who say, well, this is all well and good, but you know what? We have a private plan and we're just going to exempt out. Well, it's not that easy. So if you've been snoozing up to this point, it's time to pay attention. You, as an employer, can apply for an exemption from either the medical leave portion of this program, the family leave portion of this program, or both family and medical leave. You have to apply to the state. The state will take your application anytime on a rolling basis after April 29th of this month. When you get the exemption, if you get the exemption, it is from collecting and remitting and paying any payroll tax contributions, okay, or contributing yourself as an employer. It does not exempt you from doing the quarterly reporting, okay, which must continue. The exemption, if you are approved, is good for 1 year, can be renewed annually. As I just mentioned, the process will begin later this month. The application will be taken online. The application will be through Mass Tax Connect, which is the arm of the Massachusetts Department of Revenue, where all withholding taxes are, state withholding taxes are paid to the state. So chances are you already, as an employer, have a Mass Tax Connect account. You may not deal with it too much. It's probably your payroll vendor who's familiar with this and has your log-on information. But if you're considering an exemption, the forms will be ready at the end of the month, and the forms are electronic. There's no paper. Now, what I found shocking was the next bullet, which is part of the regulation that just came out, and that is that employers, if you apply for an exemption, you're going to receive a thumbs up or a thumbs down immediately. So apparently a lot of thought's gone into this. And if you are approved, you have to upload a copy of your approved plan. So if your private plan involves any insurance, like short-term disability insurance, etc., any policy forms have to be issued by a Massachusetts licensed insurer. If you have a self-insured or self-funded leave program, you have to furnish a bond to the state in a form and amount that's required by them, and there's been no indication of what the bond amounts would be. Obviously, if you get a thumbs down and your exemption is denied, you can ask for a follow-up review and have it reviewed. Okay. Once you get approved, now the Department of Family and Medical Leave has the right to come in and audit, when they feel like it, your private exempt leave plan. Okay, so you get the approval. Let's say you don't have to collect and remit, but you still have to operate the plan in accordance with the state rules, or at least as good as the state rules. And they have the right to come in and audit that. In addition, you get an exemption for your private plan. So now you're operating your private plan, you're not paying into the state, and you deny leave benefits to one of your employees under your private plan. They have the right to go in and appeal that denial to the state under the Paid Family and Medical Leave rule, believe it or not. So in one sense, you're freed from the collection and remittance of payroll contributions, but you do submit your private plan to audits, and also any claims that you deny can be appealed to the state. And if they overturn that, they overturn your denial, guess what? You're paying the benefit under your private plan, which is an interesting development. Now, in order to be exempt, your plan has to provide the same rights, at least the same rights and benefits and protections as the state program. So at a minimum, you have to have the same number of benefit weeks for the same reasons, right? Family leave, medical leave, etc. You also have to provide it to the same family members. And there's a very broad definition of who is a family member under this program. It's broader than the FMLA, all right? You also, at a minimum, have to have at least the same wage replacement rates and the same maximum weekly benefit, or at least the same. Obviously, it could be better. And the employee's cost to participate in your program can't exceed his or her cost to participate in the state program, which is about employees would contribute about $3.20 per $1,000 of wages earned under the state program. Obviously, the job protections and the benefit continuation provisions have to be included in the private plan. And then I underline this next bullet, and this comes right out of the regs that were just released. Your private plan, in order to be exempt, in addition to all the other bullets in front of this one, must specifically state that all presumptions shall be made in favor of the availability of the leave and the payment of leave benefits, which basically says we're going to liberally, very liberally construe our private program. And if you don't, they're only going to appeal to the state anyways, out of your private program if you deny them. Okay, so these are some of the considerations you need to think of if you've been more or less planning or considering exempting yourself from this process, all or part of this process. Now, once you get exempted, your exemption can be withdrawn. If you don't pay the benefits, or you don't pay them in a timely and consistent manner, or you failure to maintain an adequate security deposit, I believe that might be the bond. You misuse your private plan funds. You don't submit reports as required. There's lots of reasons that they can come in and yank your private plan exemption. So what's this going to cost? We know it's 0.63%, which is 0.0063 of your payroll. All right. So the employer can deduct from wages up to 40% of the contribution required for medical leave, and the other 60% of the medical leave portion of the 0.63% is contributed by the employer. Same on the family leave side. The family leave is only 0.11% of the 0.63% of the cost of the entire program. And as an employer, you can deduct up to 100% from the wages of your employees. You do not have to contribute to the family leave portion of this cost. Now, if you're an employer with an average total workforce that's less than 25 individuals, you're not required to contribute your portion of the medical leave contribution. Okay? Which means you're essentially not contributing anything. The payroll tax is subject to annual adjustment each October. The wage base that this 0.0063 will be assessed against, excuse me, is the state Social Security, is the federal Social Security wage base, which is for this year $132,900. Some people have asked, can I cover more of the cost of the employee portion of the payroll tax for some employee classes but not for others? Has not been dealt with at all in the regs. I'd be cautious in doing anything that isn't clearly delineated in the regs or the statute. Personally, I don't see that this would necessarily be a big deal. If you're seriously considered something like this, we could even go in to the Department of Family and Medical Leave and pose it as a question. So just a pictorial view of how the 0.63% breaks out and what portion of that is the medical leave, what portion is the family leave, and what are the minimum and maximum amounts that an employer must pay or must collect from employees. Now, you're also going to have to, as an employer, provide quarterly reports, and any payroll taxes that you've collected, as well as any employer contributions, will also be paid quarterly, and that'll start this October after the first quarter, July 1 to September 30th, is over. Now, you will file quarterly wage reports, and you're going to be remitting this 0.63% contribution. Again, this all goes through the Mass Department of Revenue's Mass Tax Connect system. Now, I know that quarterly wage reports are filed with the Division of Unemployment Assistance. There's been no indication that they're the same reports or that duplicate reports would be filed in each place. If you employ self-employed individuals as 1099 contractors, you're also going to report the amounts that you pay to them during the quarter. All right. Although no contributions are collected from those self-employed individuals, you're just reporting on them unless those self-employed individuals make up more than 50% of your workforce. In that case, you're going to have to pay towards their, you're going to have to treat them as employees. All right. So you're going to do this quarterly reporting. Then the Department of Family and Medical Leave is going to calculate what your quarterly obligation is going to be. And you're going to need to pay that by the end of the month following the close of the quarter. Okay. So what is the average total workforce? How do you determine whether or not you have fewer than 25 people? If you have fewer than 25, you as an employer do not have to contribute your 60% towards the medical portion of the family leave contribution. All right. So basically, in order to calculate your average total workforce, you go to the previous calendar year and you aggregate all the number of your employees, everybody, full-time, part-time, seasonal, you name it, during each pay period of that prior calendar year, and then you divide by the number of pay periods. If your workforce is more than 50% contractors who are receiving a 1099, those individuals are added into the aggregate number of employees to determine the average total workforce. Okay. Now, just because these benefits are available through the state, there is somewhat of an eligibility. There's a financial eligibility test, which again is adopted from the Mass Unemployment Benefits Law. And so before an employee applies for benefits through the state, that individual must have had earnings of at least $4,700 paid from all sources. Doesn't have to be just from you as an employer. Could be from someone they worked for before you. If it's in the calendar months prior to filing the benefits claim. Okay. And what are qualifying earnings? Qualifying earnings are wages paid to an employee, payments made to a contract worker. If workers make up more than 50% of your workforce, remember I said that if they made up more than 50% of your workforce, you as an employer must treat them as employees for these purposes. And obviously earnings from self-employment would be the qualifying earnings. There are penalties. Basically, if you fail or refuse to make these contributions, when they catch you, they will make you pay these contributions on your entire payroll. And if any of your employees were in the system and actually received benefits from the system, you're going to have to reimburse the state for those benefits as well. In addition, if you do not provide the notices to new hires, there's a penalty of $50 per employee or contractor for any first violation, and then it jumps to $300 per employee or contractor for subsequent violations. So who's a covered individual? Well, there are, again, no minimum hours to be worked. There's no length of service requirement, but there are those financial eligibility requirements that we just talked about. Self-employed individuals, you can elect into this system, but if you elect in for 3 years. Okay, it's a 3-year lock-in. Your former employee may also be considered a covered individual under your program if their leave starts within 26 weeks following their separation of employment from your company. Now, if they move to another company right away after they left your employ, they're going to be, their new employer pretty much is taking over, right? But if you have someone who leaves your employ and is not employed immediately thereafter and remain unemployed, if their leave starts within 26 weeks of their separation from employment with you, then they're still a covered individual by virtue of your employment with you. Now, I call this the crazy statement of scope because I thought that I understood who was in and who was out in terms of who's a Massachusetts employer, who's a Massachusetts employee. Now, this statement of scope appears in the new regs that were released a week ago, the March 29th regs. And this language is verbatim taken from the Massachusetts Unemployment Insurance Law, which is Mass General Laws, Chapter 151, capital A, Section 1, which is the definitions. And basically, what this is saying is if you have someone who's working in Massachusetts and their service that they're doing is localized in Massachusetts, then they're going to be a covered individual. Even if they do some of their work outside of Massachusetts, as long as that work outside of Massachusetts is incidental to their Massachusetts work. All right, so if they do some temporary, transitory, isolated transactions outside of Massachusetts, but everything else is pretty much in Massachusetts, then the service is localized there, and that covered individual or that individual is considered covered by this program, and the employer for whose services that individual provided would be considered a mass employer for these purposes. Then they go into this, what I call the crazy part, where they say if the service is not located in any state, I assume that means it's not located in Massachusetts, or is not localized in Massachusetts, but some service is performed in the state. You look at whether the individual's base of operations are here in Massachusetts, and that would make it good enough to make them a covered individual. If they don't have a base of operations in Massachusetts, but their services are directed or controlled by an entity within Massachusetts, then they're a covered individual. And finally, if there's no base of operations here in Mass, and the entity that's directing or controlling the services aren't based in Massachusetts, then you look as to whether or not the individual is a Massachusetts resident. Now, I can tell you that that's why I call this crazy. There's really no way for anyone to look at this and determine any gradation of services. If you're a Massachusetts-based employer, you have employees who work in Massachusetts, that's pretty clear. Outside of that, this really is very hard to apply. Now, I did indicate that this very same language applies for Massachusetts unemployment insurance. This is taken right out of the statute for the unemployment insurance statute. So one shorthand might be, you as an employer, are you subject to Massachusetts unemployment insurance with respect to that individual? If you are, then you're going to be subject, you and your employee are going to be subject to the paid family and medical leave statute. I genuinely hope that the commentary that comes in now, there'll be 2 public hearings, and any written commentary will try to focus the Department of Family and Medical Leave on this particular piece and to get some clarification or some working examples. So, self-employed individuals. You might think of a self-employed individual as a plumber or a roofer or a tradesperson or whatnot. And if they want to buy into the system, they can, because they're not an employee; they're an owner. But self-employed individuals include sole proprietors, members of an LLC, LLP, or any individual whose net income has to be reported to the Massachusetts Department of Revenue, and that individual resides in Massachusetts. So if your business is organized as an LLC, all right, and you're being taxed as a partnership, and you're a member, you're self-employed, and you're not covered by this unless you buy in. If your corporation has elected S corporation status, all right, and you're a greater than 2% shareholder in the S corporation, guess what? You're self-employed, and you fall into the piece about the net profit or loss required to be reported to the Department of Revenue, and you're not covered by this program either unless you buy into it yourself. Okay? Again, you can elect in for a 3-year lock-in period. To elect coverage, there's an application for that. Again, it's to register. You can do it through Mass Tax Connect. You have to file quarterly reports and make quarterly payments. You'd have to pay the full 0.63% on your earnings. And you're not immediately eligible for benefits, by the way, although right now that's not a big deal because no one's immediately eligible because we've got this 18-month run-in. Now, as I've told you before, family member is defined, is extremely broad. The only change that I saw based on the new regulation is that in the last bullet, a child has to be under the age of 18. So there's it doesn't matter that they've covered under your health plan until age 26. A child has to be under the age of 18 unless they're disabled. Okay? There is a claims process, and a great deal of the 30-plus pages in the March 29th regulation deals with claims, certification of the claim by the employee and their doctor and whatnot, appeal provisions. All of that are really too detailed to summarize in depth. And quite honestly, it applies to the benefits paid by the state. You're not going to be adjudicating any claims like this unless you've exempted out and you've got to follow a process that's close to this. But what you should know is that there is a requirement that when the Department of Family and Medical Leave receives a claim for family or medical leave benefits from one of your employees, they may request and probably will request information from you, and you have just 5 business days to provide the information to them. And here's a list of the information, okay? Their wage earnings, their position, hours worked, etc. Okay, it's all there. So again, when I said early on that there are administrative burdens, even though this is not your hunt, okay, the claim was submitted, you collected the payroll tax, you sent it to the state, and the claim is being filed with the state is back here at your front door and they want this information. Now, for some larger employers, you could be processing hundreds of these a month. You'd have to be a pretty large employer, but you get what I'm saying. Once benefits are approved, everyone will be notified, and the benefits, once approved, can later be amended, extended, whatever needs to be done. Now, we need to talk about carve-outs and reductions. I had said to folks who asked me after the January 23rd draft regulations were put out on the street for public comment, the working draft, is people said, gee whiz, how are we supposed to offset our benefits against the state benefits if the state never tells us what they're paying that individual? And I said, that's because if you look at some of the language, the state is anticipating that they're going to offset your benefits. They are not anticipating that you as an employer are going to offset your benefits against the state, what the state's paid. And here it is in this current reg. The weekly benefit amount that's paid by the state will be reduced, will be offset, okay, by wage replacement amounts that your employee receives from unemployment and workers' comp and what have you, any other state or federal disability laws, or a permanent disability policy or program of an employer. I assume this means LTD. The weekly benefit amount will not be reduced by any wage replacement received from a STD, temporary disability policy or program of the employer, or a paid family or medical leave policy of the employer, unless the aggregate amount that a covered individual receives exceeds the covered individual's average weekly wage. But the way this is written is that their benefit, the state benefit, will not be reduced unless, which to me means that if your program and the state program together basically pays 100% of their average weekly wage or more than that, the state's going to reduce their benefits and let you pay. They're going to do the offsetting, not you. Then they have this, I guess I'm crazy, the last bullet, and this is verbatim right out of the regulation. However, an employer that makes payments to a covered individual during the paid family and medical leave that are equal to or greater than the amount required by the proposed regulations. So basically, if you pay benefits that are equal to or greater than what the state would have paid, then the state's going to end up reimbursing you for those amounts. So again, not very clear. I wish I could have more detail for you, but again, this is something that we really need to see clarified in the final regulations. In addition, if employees needing a leave of absence for a qualifying reason, they can choose to use their accrued paid leave if they wish. Rather than apply for the state benefit. But when the employee does that, you as an employer basically have to inform the employees that use of their accrued leave doesn't buy them any more time under the paid family and medical leave law. There's really no stacking of leave periods. So if an employee says, hey, I got a month of vacation, I want to take the vacation because I'm getting paid at 100%. and I want to cash in my vacation for 4 weeks, and then I want to take 20 weeks of, assuming I qualify for it, paid medical leave for my own personal condition, no can do. You, as an employer, at the time that decision is made by the employee, need to inform them that if they take, in my example, 4 weeks of vacation, the most that they can get under a paid medical leave would be 20 weeks minus the 4 weeks of vacation, or 16 weeks. In essence, the employee cannot be paid the state benefits and accrued leave at the same time. We're coming to the end, folks. There is, as you know, an initial 7-day waiting period before any leave benefits are paid by the state. That 7-day waiting period counts towards the 12 weeks or the 20 weeks, believe it or not. Now, there's this statement that says, and there's been a lot of question about the fact that if someone takes paid family and medical leave from the state, it doesn't affect their right to accrue vacation time, etc. But the question has always been, can they accrue benefits during the leave period? And you'll see the underlined portion in the next bullet. This was clarified by the regs. The leave period itself is not required to be treated as credited service. Okay? However, when they come back, the fact that they took the leave period should not interfere with their right to continue to accrue vacation time, etc. Also, there's been a lot of questions about what do we do with employees? They're out on leave. We have to continue to pay their health insurance coverage as if they haven't left. How do we get the employee piece of that money? And there's just a statement in the reg that says that when the health coverage is continued during the leave period, the employee portion of the cost has to be paid to the employer by the employee in accordance with the employer's own policies and practices, as long as they're uniformly applied. So does that mean that an employer that's subject to federal FMLA and already has a policy or whatnot in place might use the same type of policy here? This is a little better, but it's still leaves a lot to be desired. So next steps for you folks is, obviously we want to be acutely aware of what's coming down the pike in the next 3 months. Okay, recent developments. You should check their website. Smith Brothers will also keep you informed. If you are interested at all in considering an exemption from all or part of the state program, you need to watch for the application coming online electronically April 29th. All right. You should have, and don't wait till the end, a conversation with your payroll vendor. Okay. Don't assume that they're well versed in this topic. People made that mistake with other things like employer reporting under the Affordable Care Act. And see what's going on with how they intend to handle this, what support and whatnot will they provide to you. If you have a short-term disability program, it won't hurt to touch base with your STD carrier, or if that carrier is just acting as a third-party administrator, to see what, if anything, they will do. Now, we are getting receiving some information that there will be carriers that will be providing services to employers to help them meet their mass paid family and medical leave obligations. And so there are, I believe one of them is the Hartford, and I think the other one is the Principal. Don't hold me to that. I'm just doing that from memory, who are in the works in terms of developing the support and whatever their support product in order to operate this on behalf of employers. Now, you're going to need to put some procedures in place. For instance, when you deliver the new hire notices, you got to track who'd you send them out to. Did you get them back? Did you get the acknowledgement back? Etc. You're also going to have to decide before you deliver those new hire notices, you need to decide what you as an employer are going to contribute towards the cost of this program. There are some minimums that you can contribute and some maximums that you can collect from your employees, but it's on a sliding scale. Someone called up recently and said, can the employer pay the whole thing, the whole 0.63% if they want? Sure. Why not? But those decisions have to be made, and what you're doing is put into the new hire notice. Okay? So it's something that needs to be done before your payroll vendor starts taking money out and before you distribute your notices. Yes, consider your current leave policies and what you might want to do for changes. If you are applying for an exemption, I'm thinking that if your exemption is automatically granted and you are intending not to collect or remit any contributions come July 1, to my mind, that means that your current private program, or however you amend it between now and July 1, is going to need to be in place on July 1. Okay? It's going to have to be as liberal as the state program, as if the state program were going into effect. Benefits were going to be available on July 1, 2019. So as you can see, there's a lot on people's plates. There is a lot to do between now and July 1. There are also some issues where we need some clarification, particularly in the gray areas where we're talking about who's a covered employee, they live here, they work there, vice versa. What's been provided in the regulation is not helpful, and we need some clarification on those issues. I want to go over. I know that I've run over a bit. I'm going to kick this back to Don and to see what, if anything, we have for questions that we can ask or answer for those folks who took the time to type in a question. It will try.
Okay, thank you.
And for those who have the time to wait and wish to hang on a little bit.
Yeah, so we're going to take a little bit of time for questions right now. And as you look at your screen, since everyone is on mute, on the right-hand side of your screen in those gray boxes, there is a box called questions. As of this moment, there are no questions, so I take it either everybody was blown away by Rick's presentation or is absorbing what is a lot of information, and still, as we see, no final regulations out, and some things still being determined, such as the crazy statement of scope, which I enjoy. But please put your questions in there. And what I will also say is that even if you have questions after today, please reach out to us at Smith Brothers, either your team member, or you can reach out to me directly. Again, my name is Don Rowe, and I'm the service and compliance leader here. And my email address is drowe, D-R-O-W-E, at smithbrothersusa.com. But you can also send out questions after this call. I'm still not seeing questions pop up. Go ahead, Rick.
Are you okay? I don't know why. It might be a technical issue. I do have. There's some questions that are popping up. I'm I don't know why it's only hitting one of us and not the other. There are folks who are indicating that the link to the handout is not working for them. And so what I suggest, if you don't mind, is if you contact Don Rowe, he has a copy of the PDF, and he can shoot that out to you by email. Would that be all right, Don?
That's perfectly fine. One of the things I will say is that we are recording today, and we do have, we will be making a link available. We're also, which can be sent to you. Again, contact us or your team representative, and we are going to be posting this on the Smith Brothers website. So we'll have a couple of methods to get the information out to you. I am starting to get some questions in now, Rick. I think
Okay.
I identified the technical issue.
Perfect.
So someone is asking, going back to our crazy statement of scope, whether this means that out-of-state salespeople are covered. They don't live or work in Mass, but are directed by a Massachusetts-based company.
There has to be at least some services provided in Massachusetts. If you go back to that, slide, there has to be at least some services. May not be localized in Massachusetts, but if there are some services provided in Massachusetts, but not localized in Massachusetts, then you look at those other pieces. So if you have individuals who, at least this is my take, who live in another state and work in another state or states because that's because they're a sales force across the country or wherever else regionally, if they're not providing any services at all in Massachusetts, I don't see where this would apply. And I do see a lot of questions here that talks that we're based in Connecticut. How is this impacted? That is a good question. I think that this. I think the scope statement was supposed to be helpful. I think it's just muddied the waters quite a bit. So for you, of those of you who have entered a question, and I see some here that are pretty specific. If we're Connecticut based, we don't have employees in Mass, or they live in Mass but they work in Connecticut, et cetera. Again, all of these issues need clarification. But I will tell you that just before you panic, just step back, look at that slide again. It's really verbatim from the regulation, and there needs to be some services, if not localized in Massachusetts, which is the first part of that. If it's not localized in Massachusetts, but there are some services performed in Mass, then you look at the rest of the bullets. So for all of you who say, they live in Mass, but they don't provide any services in Mass, my sense is that based on this language, they're not covered because there's no services in Massachusetts, for starters. Someone asked about the herd form. Is there any change to the herd form requirement? This has nothing to do with the herd form, the Massachusetts herd form. The Massachusetts herd form deals with our other pet project, the EMAC supplement, and who's on Mass Health. Okay, this is entirely an entirely different animal. Go ahead, Don.
I was just going to say another one is someone asked, so it sounds like if we provide short-term disability at 60% plus allow the use of sick time to make up the 40%, the state may reimburse us for some of this. Is that a correct interpretation?
Not clear. Not clear. I put that statement in quotes again. That came right out of the reg. Verbatim. That's not my interpretation. I wish
Okay.
I wish I could, I wish I could clarify it more than what's there. But these are, these are the issues.
Okay. Another question is, can the notice to the new employee's acknowledgement be in the form of a checklist of signed items provided at time of hire, or does it need to be a separate and formal acknowledgement?
I think that it probably could be put in a checklist. I think you'd want them to check an initial that particular line. It would be safer to have a separate one, but I understand that creates administrative issues and burdens and costs. But the more you try to normalize it, someone else had asked me a while ago, well, can we put this notice in the handbook? Because we're going to hand the handbook to every new hire, and they have to sign that says that they've received a copy of the handbook. I don't believe that that's adequate. First of all, where's the notice going to be in the handbook? Is it going to be on the first page? Is it going to be on page 73? And what does the acknowledgement of the handbook say? Does it say I've received a copy of the handbook, and the notice is on page 73 that they never ever saw, and I'm just acknowledging that I got the handbook? You just have to be, folks have to be careful what they generalize, and the safest bet is to take a conservative approach, at least for the time being, until there's more experience with this and/or additional guidance. But if you're going to say, well, we're going to develop an administrative practice, you have to ask yourself, how does that change someone who's compared to someone who's adopted a conservative approach with a standalone notice with an acknowledgement piece attached to that must be returned.
Okay. Another question, Rick, is how will the state help us manage intermittent leaves?
I think the state's going to have their hands full. I wouldn't depend on too much help from the state. Obviously, if intermittent leave has been approved by the state, the employer will be notified that the leave has been approved, that the leave is intermittent. How it works after that, I don't even know if the state knows that. I've talked to a number of my colleagues. Okay, we tend to be a little skeptical. I admit that. But even the state's intent to rule or adjudicate a claim in 14 days from the day it's received, I don't know how many bodies they have or how much they're going to staff up between now and January 1, 2021, but they're probably going to need about as many people who would fit in Foxborough Stadium to sit down. I think they're going to be inundated with claims, and I think it's going to be an interesting time. So I understand that from the employer perspective, the intermittent leave is being approved by the state. Yes, that impacts the employer. How is the state going to help you, or at least let you know when the intermittent leave is being taken, etc.? That's a claims and administration issue that's going to be down the road.
Okay. Great, thank you. Another one is regarding the new hire notices for new hires. When do they have to begin going out? What date?
Well, they have to be delivered within 30 days of their start date. Just remember that delivered means what we consider delivered, which is sending it out or hand delivering it or providing it, or maybe it's even online if you're doing you have electronic enrollment and whatnot. Although a lot of these people aren't even going to be eligible to enroll in your normal benefits, right?
Right.
So online enrollment or at enrollment time might not help, but as part of the onboarding process, they're going to need to be provided with the notice, and the acknowledgment's got to be collected within 30 days of their start date. So I'd start as quickly as possible. I don't mean send it out now, because we're looking at new hires. I assume on or after July 1, 2019. But the policies and procedures that an employer is going to use to administer that should be put in place by then.
Okay, thank you. Someone else is asking, Rick, if you know if the employee contribution will be pre-taxed on a pre-tax basis.
Doubtful. I don't see how. Usually, here's the reason I say that. The tax is a payroll tax. So how can you take a contribution? How can you take a payroll tax pre-tax? All right. Mm-hmm. We take benefit contributions pre-tax, and then the leftover wages or salary or what have you is subject to state, federal, FICA, whatever. There's been no indication whatsoever that this will be done on a quote-unquote pre-tax basis. I don't see how it could be to take a pre-tax contribution of a tax assessment on wages.
Okay, that makes sense. Rick, someone else is asking.
Well, there's a real issue there with you, Don. If you think anything about this makes sense. I'm sorry, I'm just being.
I get what you're saying. Just another question is, and this may be a longer conversation, but how different is the eligibility for the Massachusetts Paid Family Medical Leave versus FMLA? I know this seems to, and you alluded to it during the presentation, that this, for example, the definition of a dependent in this is much broader.
That's right. In terms of grandparents and siblings,
right,
and things of that nature, which are
the definition of a child, I think, is broader. Yeah.
It is. So,
does that? I have been told from, and see if you've confirmed this. I've been told that while the intent may be for this and FMLA to be concurrent, to run at the same time, that it's still being looked at whether, for example, if you took time off under this program for a grandparent, that would actually not go under your FMLA. That would only be under PFML. In theory, somebody could then take FMLA for a spouse because it would not be a concurrent program.
That is exactly true. And it's one of the issues that I'm following along with some of my colleagues, is that the statement is made that this paid family and medical leave will run concurrently with federal FMLA and will also run concurrently with the Massachusetts Earned Sick Time Law and the Massachusetts Parental Leave Law. The issue is that, as you point out, in some cases, the qualifying reason for taking the leave under this new Massachusetts program does not comport with, is not the same as FMLA, for example. All right. So what do you do? I mean, if someone was going out for birth of a child, chances are everything would line up nicely between this paid family and medical leave law, the parental leave law, and FMLA. But what happens if the first leave that's requested for the year deals with someone who needs to go and take care of their grandparent for a serious medical condition? That is not a qualifying reason under the FMLA. So how can it run concurrently? Okay, because it's not a qualifying reason. You're not even entitled to FMLA a leave under FMLA for that purpose. And so, as you rightly point out, if I were to go out to take care of a sick grandparent and get 12 weeks of paid family and medical leave under the state program, and then my wife has a child, or I have my own medical condition, or my spouse does, I think, although it's no longer paid, right? Because FMLA is not paid, but I should probably be entitled to another 12 weeks of leave. It may be paid if it's my own medical condition under an STD program, but because I'm not using STD, the short-term disability or whatnot, it's only going to apply to my own medical condition. Mm-hmm. It's not going to apply to some other family leave issue, whether it's covered by FMLA or not. So I think there is a kind of a loophole there. And well, someone said, well, why doesn't the state just say, well, it runs concurrently? So if you use 12 weeks to take care of a sick grandparent under this paid family and medical leave law, and apply the same 12 weeks towards FMLA, should you need FMLA leave for another reason later in the year, that's nice. But I think the feds would have a little issue with that, where the state is denying, or an employer is denying an employee the ability to take their FMLA under federal law because they took a state leave that was for a reason that didn't comport with the FMLA requirements. So okay. It'll be an interesting issue.
Interesting to watch, right? Thanks for clarifying. I think we have time for just a couple more. Can you explain the 50% 1099s? It's kind of, how do we calculate? Is it 50% of all vendors or 50% of staff versus 1099s?
I don't think we're necessarily talking about vendors. Okay, we're talking about contract workers who would likely be working for the employer for the employer's business. So no, I don't think someone coming in to fix the copy machine is, even though they're a vendor, they're not necessarily considered a self-employed individual. So contract workers are self-employed individuals who do contract work for you. It's not just going to be every vendor that you might send a 1099 out to at the end of the year. They need to be someone who is you employed as a vendor as part of your business, not to come fix your copy machine or what have you. And so what happens is, if you are a business, apparently, where more than 50% of your workforce is you're paying independent contractors, essentially.
Mm-hmm.
Okay. Those independent, once you hit more than 50%, more than 50% of your workforce are independent contractors, which is probably a better way to put it, because everyone kind of has a better idea in their mind of what they know what an independent contractor is, give or take.
Right.
Then they are figured in as an employee in your head count to whether or not you have 25 or fewer than 25. And they are also, you'd also be making a contribution as an employer. You'd be making a contribution based on the amounts that were paid to those independent contractors.
Okay, good. We are approaching the end of this. I do want to take a moment to just go over a couple of housekeeping issues. I see several questions in here. I know a number of questions have been about this crazy statement of scope. Hopefully we've answered that somewhat. But if you have follow-up questions on this, please come back either to me, that's Don Rowe at Smith Brothers, D-Rowe, R-O-W-E, at smithbrothersusa.com, or come to your Smith Brothers representative. Please don't reach out to Rick directly, just so we can help control this. He does a lot of different things, and we appreciate his role here, but we'll help get your questions answered. Sorry, we actually haven't been able to get to every one of them, so if you have a follow-up question, again, please feel free to shoot me an email with that. I see we've had a few requests come in to me for copies of the presentation. If you need that, we'll get that out to you. Again, this session has been recorded. That link will be available. We can send that out to people, and it will be posted on the Smith Brothers website. So with that, I'd like to thank you for your time and attendance today. You know, this is an ongoing item. We'll keep you informed, and as at least one person in the questions has pointed out, Connecticut currently has comparable legislation going through the legislature. So this is something we're going to be seeing a lot more of than a lot less of as we move forward. But as you move forward, please reach out to us with questions. We appreciate your business and your confidence in Smith Brothers, and we want to say enjoy the rest of your day. And with that, this concludes today's webinar. Thank you very much.